Hello and welcome to Moneylife. This is Sucheta Dalal. This week, let's talk about what the Supreme Court is doing, and it's again about all of us. The question that I'm asking today is: will the Supreme Court finally rein in rogue asset reconstruction companies? Now, some of you will say, what is an asset reconstruction company? Well, this is a company that buys troubled assets or bad loans. And you know how huge that number is. It's over tens of lakhs of crores, right, over the last 10 years. Now, these asset reconstruction companies are supposed to buy these troubled assets so that they clean up bank books, find a way to maximize recovery from the bad loans, and restore financial stability in the system. So they're a key player in the system, which allows banks to do their banking function and allows a specialized agency to take over bad loans and recover maximum value. It's not happening. And that is why we're talking about it. So they fulfill the first function quite efficiently. They take over bad loans, but their role has become increasingly controversial over the years because when ARCs acquire loans from individuals, you default on a house loan or even a motorcycle loan, or God help you if you are a small and medium sized company and you pledged your shirt literally the home you're living in because you want to be an entrepreneur, you want to start a business. If you make a mistake, they are ruthless. They will not attempt to maximize whatever you have secured, and they will actually send you into bankruptcy. But when it comes to large corporate borrowers, ARCs have been doing something completely different. And any of you who's a home buyer and has done subvention, whatever, you will know what exactly it means, and I don't need to explain this further. Why am I talking about it today? Because I want to point out that it is not as though regulators are not aware. The Reserve Bank of India in 2024 had gone public with the deputy governor making a speech in which he expressed concerns that ARCs were acting as conduits to evergreen bad loans, make them look fine, make the bank look fine through structured transactions that circumvented all regulation. This is frankly dubious and it should be punished really badly, has not happened. So from 2024, nothing happens. RBI makes speeches, tightens its conditions, and I'll tell you what happens to that a little later. Why I'm talking about it today is that the Supreme Court, I must say, has been very, very pro small borrowers. So last week, the Supreme Court offered serious hope of aggressive judicial scrutiny on ARCs. On 19 June, a bench comprising Chief Justice Suryakant and Justice V. Mohana heard a public interest litigation that was Pratiksha and others versus the Union of India. Advocate Ashwini Kumar Upadhyay was representing it. This PIL alleged that 1,537 crore of debt owed to a consortium of public sector banks, led again by State Bank of India, was settled, believe it or not, for just 73 crore through transfers to two ARCs, Prudent ARC and Phoenix ARC. And this group had been making representations about it being sold so cheap, nothing happened. What is the story? This is a company called JKM Infra Projects based in Noida, borrowed heavily from banks between 2012 and 2015. Banks, as usual, again, this is where the collusion comes in, did not take enough collateral. If you borrow, your whole house is pledged, even though you have paid an upfront amount. But here, borrowing in thousands of crores and hardly 72 crores of collateral. In 2018, once these loans go bad, this is a template. Banks wake up well after all kinds of evergreening and restructuring has happened, and then they order a forensic audit. So Ernst Young did a forensic audit in 2018 when the borrowing happened from 2012 to 15. It revealed a diversion of 902 crore to shell companies. Banks were sleeping. Despite this, banks were in no hurry to classify it as a fraud or a bad loan and file a complaint to the CBI, as is their duty to do. So they sold the loans to ARCs at a steep discount because this is an area where nobody has asked too many questions until finally affected people go to the Supreme Court. So the PIL has highlighted inaction by all kinds of agencies, including regulators, RBI, and others, and it now wants a judicial commission or an expert committee to probe this large scale banking fraud facilitated by ARC transactions. Justice Suryakant obviously was quite livid when he heard this. He minced no words. He observed the possibility, and I'm quoting, of a very deep rooted nexus between borrowers, ARCs, and banks. He also stressed that public money demands serious recovery efforts, not casual write offs. Actually, private money also does because it's money belonging to you and me. But be it that as it may, at least hopefully, public money will lead to huge judicial scrutiny. So the court has issued notices to union ministries of Home and Finance, the Reserve Bank of India, Serious Frauds Investigation Office, the Securities and Exchange Board of India, and of course the seven lender banks starting with SBI, Canara Bank, and Union Bank. It also has sent notices to the ARCs, to Ernst Young, which did the audit, and the promoters of the company. Now, readers of this column and video blog know that these are not new issues. Moneylife has repeatedly flagged dodgy deals by banks and ARCs and how they are particularly cruel and extortive to small borrowers. The difference this time is that the Supreme Court, Apex Court, has taken cognizance, and it has the ability to cut through bureaucratic red tape, cut through regulatory rivalries, looking the other way, competing SFIO, not listening to SEBI, not listening to RBI, CBI, accountable to Home Ministry. The Supreme Court can cut through all this and force accountability, and it has done this before. In fact, in a landmark order in April 2024, the Supreme Court directed the CBI to probe the unholy nexus between banks, real estate developers in subvention schemes. Here again, somebody was promised that they can escape interest for a while. They never got possession. The promoter turned defaulter, and banks were recovering from individuals. This led to, and mind you, the CBI tried to wiggle out of it, but the Supreme Court said nothing doing. This has led to multiple first information reports, a special investigation team. That order also came from a bench which had Justice Suryakant. Along with him was Justice N. Koteshwar Singh at that time. So you want to know what happened? The CBI went on to register 28 cases in the first phase, followed by 22 more after a nationwide crackdown that expanded the probe. And those of you who are on Twitter will know that they tweet about this regularly and give you updates. This time, too, the bench has declared that it will not spare anyone, and it will revisit the very creation and functioning of ARCs if necessary. This is what gives us hope. So, if the current PIL triggers a comprehensive probe into the bank borrower ARC nexus, it could mark a significant shift in narrative from ARCs being a pure market driven solution, and it's the market that can bear. So 1,000 crore worth of assets are sold for 72 crores. That's what the market says. No, that's not the case. There's clearly a dubious nexus, and hopefully the Supreme Court will cut through it. Now, judicial examination, frankly, should go into a few things that are already raised by none other than the Reserve Bank. So, when I talked about this 2024 speech, it was by Deputy Governor J. Swaminathan in May 2024. And he flagged the following issues. He says, which means the RBI knows from its inspections very clearly, one, that banks are offloading bad debts to ARCs to clean up their own balance sheets, and they continue to recover responsibility for getting the money back as well as collateral, which means it's just a dubious structuring. Second, non transparent deals with group entities of the defaulter company without scrutiny on related party transactions. Third, incorrect reporting to the Central Repository for Information on Large Credit Systems. This was supposed to be like the CIBIL that applies to us for personal loans. And if you don't report correctly, how dubious is that? When it's your motorcycle loan, that gets reported to CIBIL, even if there's a delay. But when there's a large credit running into hundreds and thousands of crores, banks themselves cooperate in not reporting correctly. Now, Mr. Swaminathan had a lot more to say about transparency, dodgy valuation, deliberate misinterpretation of RBI directives, as well as how security receipts are structured. All this is fodder and material for the Supreme Court committee, Judicial Commission, whatever, to look at if they do set it up, because these are serious charges and none of them would have been made in a public speech unless RBI inspections proved it. Now, RBI inspection leads to action, but mind you, doesn't catch everything. You have to stop the system from being anti people or pro borrower or with an excess. So RBI, not that it didn't act. As usual, it acts with directives bit by bit drips. So in 2025, it introduced a comprehensive RBI Asset Reconstruction Company directions. These plugged critical operational and regulatory loopholes to eliminate evergreening of bad loans, moral hazard, conflict of interest in the stressed asset ecosystem. Has it worked? Not yet. Why? Because they have been given time until March 2026, which is 2 months ago. Now, these directions were interesting. Again, can be followed. They capped resolution timelines to 5 years, extendable to eight. I don't know why, because it's a bankruptcy is supposed to happen quickly. They say this will prevent warehousing, which banks do. Again, you don't need a solution like this, it could be more direct. They have weeded out marginal players by raising net owned fund requirements of ARCs. So what was happening is all kinds of builders themselves were setting up ARCs and RBI is watching it. Now they've increased this requirement to 300 crores. They have blocked bilateral non-transparent asset acquisition from ARC's own sponsor banks. I mean, look at what was going on. That this was allowed to happen and it's now being blocked after March 26. It has also mandated ARC's investment in every class of security receipts issued by them to ensure genuine skin in the game. Since these directions had a compliance deadline, like I said, of March 26, everything has remained in place and people have had to reach the Supreme Court. I'm willing to bet RBI's affidavit will document all this and say we are doing plenty. No, they are not, because directives means which are operational in March means action probably in 2028 after a set of inspection happens, which is already too late because this is going on for over 10 years. So enforcement agencies have to step in. They have already regularly unearthed sophisticated bypass mechanisms where defaulting promoters establish layered networks of offshore trusts, family offices, shell companies, and buy back bad loans at a steep haircut. So you have 1,000 crore borrowing outstanding, you have defaulted, it goes to the bankruptcy court, then the road is sold to the ARC at a discount, so nobody's interested. You do a deal with the ARC, you set up shell companies abroad, and instead of this 1,000 crores you offer a pittance 20, 30 crores, saying nobody is interested, and you buy it back, you retain control through the shell companies. ARCs are aware of this. Frankly, RBI should be aware of this. They play a key role on this acquisition of assets, often at 10 to 30% of outstanding value through sweetheart deals with defaulters. I'm sure they get paid. That's why this is a thriving business and RBI has been sleeping. At the NCLT, which is the National Company Law Tribunal, and its appellate body, similar allegations about dubious practices have surfaced regularly. Plenty in 25-26 alone. They have centered on undervaluation, related party influence, prioritization of quick liquidation instead of revival, which means asset reconstruction doesn't happen at all. It's only deal making, and ARCs have been abusing the dominant position to exercise de facto control to ensure all this happens because they step in, they control the creditors committee, they have the pledge shares, they decide who are the board observers, they control escrow arrangements, is going to be an advisor, and of course how things are voted on. In realty related cases, home buyers have accused ARCs of pushing undervalued sales or corporate debtor liquidation, which hurts them because you don't have possession and you're continuing to pay. Tribunals have increasingly scrutinized ARC resolution plans for transparency deficit, lowball bids, and attempts to circumvent moratorium protection. But all this had to slowly climb its way to the Supreme Court, and that's where we are. And since the court has reacted so strongly in the first hearing itself, one is feeling hopeful. So the Supreme Court's strong observations are great. They're a welcome signal. It looks like it will pierce the wheel of opaque ARC transactions, which have shielded banks and dubious borrowers, always at the expense of private people and public money. But the question that I have is, will this just remain strong observations in court, or will it lead to systemic reform and not just cosmetic cleanup? A strong order should ensure, and it has to be a quick order, should ensure genuine reconstruction, action by CBI and enforcement agencies now to dig it up, reverse it if required, bring the money back, instead of convenient liquidation and saying this is a market driven sweetheart deal because nobody else is interested. The Supreme Court does have an opportunity to enforce a standard of justice for all. We will wait and watch whether judicial intervention translates to such action or fades into another set of observations and powerful directives that remain on paper and will define the Supreme Court's legacy and, of course, our legacy. If you agree, share this, because the more people know about it, and very few people are interested in business, when they know what happens when they turn entrepreneurs, they're going to be interested in issues that happen behind the scenes. Thank you, and do subscribe.